Welcome to one of the most disturbing cases of inheritance fraud ever recorded in Mississippi history. Before we begin, I invite you to leave in the comments where you're watching from and the exact time you're listening to this narration. We're interested in knowing which places and times of day or night these documented accounts reach. On the morning of March 23, 1846, in the wood-paneled chambers of the Harrison County Courthouse in Biloxi, Mississippi, Attorney Benjamin Lockwood stood before Judge Marcus Fairfax to read aloud the last will and testament of Caroline Beatrice Thornton. What should have been a routine probate proceeding became instead one of the most scandalous moments in the county's history. As Lockwood's voice carried across the silent courtroom, reading the provisions that left an entire plantation to an enslaved woman, the collective shock was so profound that several observers would later describe it as if time itself had stopped, as if the words being spoken were too impossible to process in real time. The spring of 1846 found Biloxi in a state of prosperity fueled by cotton and the labor of those who grew it. The city, situated along the Gulf Coast with its white sand beaches and moss-draped live oaks, served as both commercial center and retreat for wealthy planters escaping the summer heat of their inland estates. Among the most prominent of these properties was the Thornton Plantation, established in 1798 by Robert Thornton, a merchant who had transformed land grants into agricultural empire. By 1846, the property encompassed 640 acres of prime cotton land, a mansion described in contemporary accounts as one of the finest examples of Greek Revival architecture in the state, and 52 enslaved individuals whose labor sustained the enterprise. Caroline Beatrice Thornton had inherited this empire in 1841 following the death of her father, Robert Thornton, who himself had inherited it from his father. At 33 years old, Caroline found herself in the unusual position of being a wealthy woman with no male relatives willing or able to manage her affairs. She had never married, a source of considerable speculation among Biloxi society. According to letters preserved in the Mississippi Department of Archives and History, her mother Elizabeth had died in 1843, leaving Caroline completely alone in the sprawling mansion that had once housed multiple generations of Thorntons. The plantation operated under Caroline's direct management for 5 years, an arrangement that raised eyebrows but produced no particular scandal. According to tax records from Harrison County, the property maintained consistent productivity throughout this period. Quarterly reports filed with cotton factors in New Orleans show regular shipments and standard pricing. To all outward appearances, Caroline Thornton managed her inheritance with the same business acumen her father had demonstrated. What few outside the plantation knew was that Caroline relied heavily on the assistance of one particular member of the household. Rachel, listed in property inventories simply as midwife, Negro, approximately 40 years of age, born on Thornton property, had served the family for as long as anyone could remember. According to oral histories collected by the Works Progress Administration in the 1930s from descendants of those who had been enslaved on Gulf Coast plantations, Rachel was known throughout the region for her skill in delivering babies and treating illnesses. Former house servants interviewed decades later described her as possessing unusual authority within the plantation hierarchy, frequently consulting with Caroline on matters that would typically be reserved for overseers or male family members. This close working relationship attracted attention. Margaret Sinclair, whose family owned the neighboring plantation, noted in a diary entry dated August 4, 1844, discovered during a 1956 estate sale and now housed at the University of Southern Mississippi, "I called upon Caroline this afternoon and found her in consultation with a Negro woman Rachel regarding accounts and correspondence. When I expressed surprise at seeing household records spread before a servant, Caroline simply smiled and said that Rachel understood the estate better than anyone. There was something in the way she spoke, a familiarity that seemed to transcend the usual boundaries between mistress and slave." The first clear indication that Caroline's health was failing came in October 1845. Dr. Samuel Hayes, the physician who attended the Thornton family, noted in his medical journal, preserved in the Gulf Coast Medical Society archives, that he was called to the plantation to treat Miss Thornton for severe abdominal pain and weakness. Over the following months, his entries document a progressive illness that he diagnosed as consumption of a particularly aggressive nature, though he noted symptoms that did not entirely align with typical tubercular disease. By January 1846, Caroline was largely confined to her chambers, too weak to manage the plantation directly but insisting on maintaining control of decision-making. It was during this final illness that Caroline made arrangements that would shock Biloxi society. On February 3, 1846, she summoned attorney Benjamin Lockwood to her bedside. Lockwood, according to his own account recorded in a letter to his brother and preserved in the Lockwood family papers at Tulane University, found Caroline propped against pillows in her bedroom, Rachel seated beside her, and 3 other witnesses present: Reverend Thomas Whitmore of the Methodist Episcopal Church, Dr. Samuel Hayes, and Catherine Morrison, a longtime friend of the Thornton family. What Caroline dictated that afternoon was a will that defied every social convention of antebellum Mississippi. After the standard opening provisions and the declaration of her sound mind despite her failing body, she directed that upon her death, the entire Thornton plantation, its lands, buildings, and all assets with one exception, should become the property of Rachel. The exception was the enslaved population, all of whom were to be manumitted and provided with sufficient funds to establish themselves as free people either in Mississippi or in any northern state they might choose to relocate to. According to Lockwood's account, he questioned Caroline repeatedly about these provisions, warning her of the legal challenges they would almost certainly face. Her response, which he recorded verbatim, was simply this: "Rachel knows the truth of my blood, and therefore must receive that which belongs to the blood." When pressed to explain this cryptic statement, Caroline declined, saying only that a letter existed that would clarify everything should clarification become necessary. The will was signed on February 5, 1846, with all 3 witnesses attesting to Caroline's mental competence and the voluntary nature of her decisions. A sealed letter, addressed to the Harrison County Probate Court, was entrusted to Reverend Whitmore with instructions that it should be opened only in the event the will was contested. Caroline Beatrice Thornton died on March 17, 1846, at 38 years of age. Her funeral was attended by the elite of Biloxi society, none of whom yet knew the contents of her will. The reading of that will 6 days later created immediate chaos. According to newspaper accounts from the Biloxi Herald, family members present in the courtroom included 3 cousins from the Thornton line and 2 from her mother's family, the Ashfords. All had arrived expecting to inherit portions of the valuable estate. Instead, they heard attorney Lockwood read provisions that transferred everything to a woman who, under Mississippi law, could not legally own property because she herself was property. The legal paradox was immediately apparent. For Rachel to inherit the plantation, she would first need to be free. But the will's provision freeing her would only take effect upon Caroline's death, at which point she would theoretically already own property as an enslaved person, an impossibility under state law. Judge Fairfax, according to courthouse records, ordered a 30-day stay to allow all parties to file briefs addressing this unprecedented situation. The Thornton family filed a contest within a week. Their petition, preserved in Harrison County courthouse records, argued that Caroline had been of unsound mind due to her illness, that she had been under the undue influence of Rachel who had manipulated a dying woman for personal gain, and that the will violated public policy by attempting to transfer significant property to a person of color. They demanded that the will be set aside and the estate distributed according to intestacy laws, which would divide it among Caroline's surviving relatives. It was at this point that Reverend Whitmore came forward with the sealed letter. According to his testimony, recorded in probate court transcripts, he presented the envelope to Judge Fairfax on April 15, 1846. The judge took the letter into his private chambers, instructing all parties to return the following day for his decision. What happened during those 24 hours remains one of the most controversial aspects of the case. When court reconvened on April 16, Judge Fairfax announced that after careful consideration and consultation with the sealed letter, he was prepared to validate the will with certain modifications. However, before he could elaborate, Attorney Lockwood interrupted to state that the Thornton family had reached a private settlement with Rachel, who had agreed to relinquish all claims to the estate in exchange for her immediate manumission and a cash payment. The settlement had been negotiated overnight and signed that very morning. The speed and secrecy of this settlement raised immediate questions. Several observers noted that Rachel had been present in the courtroom when proceedings began but had been called away during a recess and had not returned. When the settlement was presented, she was not present to acknowledge it personally, though a document bearing what was claimed to be her mark appeared in the court record. Most significantly, When Lockwood finished presenting the settlement terms and Judge Fairfax asked to see the sealed letter one final time, court clerks discovered it was missing from the judge's chambers. No explanation was ever provided for its disappearance. The settlement terms, recorded in Harrison County deed books, granted Rachel her freedom and a payment of $500, a sum that represented less than 0.1% of the estate's estimated value. The plantation and all its assets reverted to the Thornton family, divided among the contesting cousins according to a formula that satisfied Mississippi inheritance law. The enslaved population was not freed as Caroline had directed, but remained with the property as it was divided and sold. Rachel vanishes from Biloxi records after April 1846. No manumission papers were ever filed with the county, though the court settlement claimed they had been executed. No tax records show her owning property or paying the annual freedom tax required of free people of color in Mississippi. A woman named Rachel appears in the 1850 census of Mobile, Alabama, listed as a free Negro working as a midwife, but whether this was the same person cannot be confirmed. For more than 150 years, the Thornton will case remained a curious footnote in Mississippi legal history, occasionally referenced in law review articles about testamentary capacity and undue influence, but largely forgotten outside academic circles. The sealed letter that Caroline had written was presumed destroyed. The plantation itself changed hands multiple times before being subdivided and developed in the early 20th century. By the 1950s, only the main house remained, converted into apartments and gradually falling into disrepair. In 1998, a preservation society purchased the dilapidated mansion with plans to restore it as a historic house museum. Structural assessments revealed extensive damage requiring complete renovation. It was during this restoration, in August 2003, that workers removing wood paneling from what had been Caroline Thornton's bedroom discovered a hidden compartment built into the wall behind the headboard. Inside was a leather document case containing 23 letters. The letters, written by Elizabeth Thornton to her daughter Caroline between 1841 and 1843, were examined by historians at the University of Southern Mississippi. According to Dr. Margaret Chen, whose 2005 article in the Journal of Southern History provides the most complete analysis, the letters document Elizabeth's growing awareness of a family secret that had been concealed for decades. In a letter dated March 15, 1842, Elizabeth wrote to Caroline about her discovery that Robert Thornton had fathered a child with an enslaved woman named Sarah in 1806. That child was Rachel. The revelation emerged gradually through the letters. Elizabeth described finding old household ledgers that recorded Sarah's pregnancy and Rachel's birth in the same year Caroline's older brother Robert Jr. was born. She mentioned discovering a portrait miniature of a young girl who looked remarkably similar to Thornton family members, hidden in Robert's private papers with the name Rachel inscribed on the back. Most significantly, she wrote of confronting her dying husband about Rachel's parentage and his confirmation that yes, Rachel was his daughter, that he had provided for her education and training as a midwife but could never publicly acknowledge the relationship. The final letter in the collection, dated November 8, 1843, just weeks before Elizabeth's own death, contained the most explicit statement. "My dearest Caroline," she wrote, "I have told you the truth about Rachel so that you might understand why I look upon her with such conflicted feelings. She is your father's daughter, which makes her your sister in blood if not in law. When I am gone, you must decide what duty you owe to this connection. I cannot tell you what is right. The world we live in provides no guidance for such situations. But I trust you will act according to your conscience." The letters explained the cryptic phrase in Caroline's will. "Rachel knows the truth of my blood," referred to their shared parentage. Caroline had learned before drafting her will that she and Rachel were half-sisters, daughters of the same father, separated by the accident of their mothers' vastly different positions. The will was Caroline's attempt to acknowledge this relationship, to transfer to Rachel the inheritance that would have been hers had she been born white. The discovery of the letters prompted further investigation. In 2015, researchers petitioned Harrison County for permission to exhume remains from the old Thornton family cemetery, which had been relocated to a consolidated plot when the original plantation land was developed. DNA samples were extracted from bone fragments of Robert Thornton, Caroline Thornton, and from a grave marked only with the name Rachel, dated 1847, that had been found in what had once been the enslaved burial ground adjacent to the family cemetery. The DNA analysis, published in the American Journal of Physical Anthropology in 2016, confirmed what the letters suggested. Robert Thornton was the biological father of both Caroline and Rachel. The two women shared 50% of their genetic material. They were full sisters from different mothers, born just 2 years apart but raised in completely different worlds. This confirmation reframed the entire Thornton will case. Caroline's attempt to leave her estate to Rachel was not the delusion of a dying woman or the result of manipulation, but rather a calculated effort to acknowledge a biological relationship that society refused to recognize. The rapid settlement that stripped Rachel of her inheritance took on even darker significance in this light. What had appeared to be a resolution of a legal dispute now looked like a conspiracy by the Thornton family to prevent a woman of mixed race from claiming her rightful share of the family estate. Evidence of this conspiracy emerged from an unexpected source. In 2018, during an estate sale in New Orleans, a painting was discovered in the attic of a house that had once belonged to Thomas Thornton, one of the cousins who had contested Caroline's will. The painting, a double portrait, showed two women seated side by side against a neutral background. They wore identical dresses of deep blue silk, their hair arranged in the same style, their postures mirror images of each other. The faces, while not identical, showed unmistakable similarities. The same shape of eyes, the same line of jaw, the same expression of calm dignity. On the reverse of the canvas, a label identified the subjects as Miss Caroline Thornton and Rachel, painted by Auguste Devereux in January 1846, just weeks before Caroline's death. Accompanying the painting was a note card, yellowed with age, bearing a single line written in an elegant hand: "Do not look. The sisters still observe." The painting was authenticated by art historians at Tulane University and is now displayed in the Thornton House Museum, which finally opened to the public in 2019. The museum's exhibition includes the letters, DNA analysis results, court documents, and the portrait. According to museum director James Foster, the portrait has become the most discussed piece in the collection, not just for its historical significance but for the unsettling effect it produces on viewers. Multiple visitors have reported that cameras and smartphones malfunction when attempting to photograph the portrait. Digital images capture only static or strange distortions. Traditional film cameras produce blank exposures. The museum has documented over 40 such incidents since the painting was put on display. Technical experts have found no electromagnetic interference or other rational explanation for these failures. More disturbing are accounts from visitors who claim to have heard voices while standing before the portrait. Security footage shows individuals pausing in front of the painting, sometimes for several minutes, as if listening to something. When questioned, they describe hearing two female voices engaged in quiet conversation, though the words are never quite clear enough to understand. The voices are described as calm but insistent, discussing something urgent, something about justice delayed but not forgotten. The story of Caroline Thornton and Rachel speaks to the brutal arbitrariness of racial classification in the antebellum South. Two sisters, born of the same father, received such vastly different treatment based solely on their mother's status. One inherited wealth and social position. The other inherited nothing but generations of servitude. When Caroline attempted to correct this injustice through her will, acknowledging blood ties that law and custom denied, the system that benefited from that denial closed ranks to prevent her from succeeding. The sealed letter that Caroline wrote, explaining her decision and presumably detailing the full story of her and Rachel's relationship, was disappeared before it could be read publicly. Whether Judge Fairfax destroyed it himself or whether it was taken by members of the Thornton family who gained access to his chambers cannot be determined. What is certain is that powerful interests wanted the truth suppressed, and they succeeded for more than 150 years. Rachel's fate after being forced to relinquish her inheritance remains largely unknown. If the Rachel who appears in mobile census records was indeed the same woman, she lived another year before dying in 1847 at approximately 41 years of age. She left no known descendants, no property, no written account of her thoughts about the sister who tried to give her everything and the system that took it all away. She exists in the historical record primarily through the documents created by others, property inventories, witness testimonies, DNA samples. Her own voice is absent. In the restored Thornton mansion, now a testament to both architectural beauty and historical horror, the double portrait hangs in the main parlor. The two women, dressed identically, look out at visitors with expressions that seem to ask uncomfortable questions about inheritance, justice, and the stories we tell ourselves about the past. Their similarity is undeniable, their shared genetic heritage evident in every feature. Yet only one of them was allowed to be a Thornton. Only one of them could inherit. Only one of them mattered in the eyes of the law. And on certain nights, according to museum staff who have worked there long enough to overcome their skepticism, you can stand before that portrait and hear it. The sound of two sisters finally speaking freely to each other, their conversation crossing the boundaries that separated them in life, discussing in whispers what should have been theirs by right, what was taken through law, what remains unresolved. The blood knew the blood, as Caroline wrote. But knowing was not enough to break through the walls society had built between sisters. The portrait remains as testimony to a relationship that existed but could not be acknowledged, to an inheritance claimed but never received, and to the persistent questions that haunt us still about who belongs to whom, who inherits what, and whose blood counts as blood at all.